premier academic institutes and professional organizations. I, Garima Gupta.
And I, Keshav Thosar.
Welcome you all to day 6, that is the last day of IEEE Entrepreneurship Bootcamp 2021. Success is not final. Failure isn't fatal. It is the courage to continue that counts. In the wise words of Winston Churchill, before we start with the final day of the bootcamp, we would like to congratulate you all for putting in the efforts and taking a step further towards your entrepreneurial journey.
Without further ado, let us begin with our first session for the day on intellectual asset creation. We welcome our esteemed speaker, Mr. Abhishek Pandurangi, partner and attorney at law at Khurana & Khurana Advocates, and IP attorneys. Our speaker has worked on various projects, some of which include patentability studies, FTO studies, invalidation, opposition studies, patent landscapes, patent drafting, patent commercialization, IP strategy, portfolio management, and industrial design protection.
He has handled a massive wide variety of patent and non-patent databases, along with micropad, etc. As a founding father of Closer to Patents, he was supplying expert steerage to students, character inventors, and SMEs inside the area of IPR. Sir, we now kindly request you to address the audience. Over to you, sir.
Thank you so much. Firstly, thanks for the kind reminder that I need to update my LinkedIn photograph because I couldn't recognize myself in this old photograph. So, notwithstanding that, I really am proud and privileged to be part of this event. I have had an association with IEEE, with SPIT and Professor Talele for quite a few years now. And it gives me extreme pleasure to be here and provide some inputs from my experience, my limited experience of about 15 years in IP. And thanks for choosing me to be here. It's great. And I'll try to put in some points, although 1 hour is very, very little for me to talk about IP because people accuse me of going on and on about patents for intolerable amount of time. But let me try and put some perspectives in the 1 hour. I also encourage the audience and participants, if they can, reach out and put across their questions live, because that is the best way to address people's queries that are abuzz in today's time. And while I'll be trying with case studies and other example-based discussion, a one-on-one interaction with the audience becomes very, very encouraging for the speaker. So if that can happen, that would be really good and insightful as well. So before that, if the the organizers can help me with be able to share my presentation, I'll just try to share my screen and you tell me if it's properly visible or not.
Yes, sir. Siddharth?
Are you able to see my screen?
Yes, sir, it's visible.
Is the presentation showing up?
Yes, sir.
Okay. Is it on a screen mode now?
Yes, sir.
Okay.
Recording in progress.
So the topic that I have today is dealing with intellectual asset creation. Right? Now, what is intellectual asset, which in our regular terms would call as intellectual property? In commercial and legal terminology, it's called as intellectual property. So the asset created by the intellect, by the brain, human beings have this fantastic tool which allows them to imagine, create, innovate, and apply so many different kind of solutions to day-to-day problems, and that comes from this intellect. So whatever is being created from the intellect is commonly known as intellectual property, which in today's context of a topic becomes intellectual asset. So once the property is created, it becomes an asset. Now, what is an intellectual property in terms of legal discourse? It is considered as a movable property. So all applicable laws to movable property in essence get applicable to intellectual property. And by creating this asset, by creating this property, what is the advantage or what is the benefit that the creator gets is that he can exclude others from using it. So one of the key factors of intellectual property or asset is that it is a right of exclusion. Because you can exclude others, you become sort of a monopoly holder over that particular asset or that particular idea or that particular design or that particular brand. Because there is a monopoly, there is a certain demand that gets attached to it. There is a certain exclusivity that gets attached to it, and people might be interested in purchasing or leveraging that asset. And that is how the asset really comes up into its prominence. But you have to also remember that it is not licensed. I don't need a trademark registered to start a business with a certain name. I don't need a patent to be able to just start practicing a technology or invention that I have devised at my home. I need it to exclude others from doing it. So this distinction is very important, that intellectual property or asset is not a prerequisite license to exercise or to carry out or to practice the use of that intellectual property or asset. It is only used or it is filed or it is secured to stop others creating a monopoly and thereby increasing the value of your intellectual asset, because nobody else do it without your permission or giving you license or royalty, etc. Now, what we mean that intellectual property was created can stop others from doing it. Does it mean that other people don't do it? Of course, there are many cases where there is counterfeiting or copying. When I say that they cannot do it, means that you get the right to go to a proper forum such as a court and get the others to stop. So the court becomes a deciding authority or a figure to see what your intellectual asset is, what the other person is doing, does it infringe on your intellectual asset or not, and thereby direct the other person to stop or pay compensation. Now, this intellectual asset in legal form or legal parlance is categorized in different types of intellectual property, and each of them have a different law or statute in being which enables the execution of this intellectual property via courts or other forums. And these are called, as famously everybody's heard, patents, copyright, trademarks, design, geographical indications. Now, what aspect of that particular intellectual asset has to be protected becomes the deciding factor of which type of IPR or intellectual property right are you going to secure. Now, if I start a company and it becomes famous because of my product, it's good quality, it's good usage, but my name is becoming more and more famous. So as a result of good quality service of, say, Airtel or Vodafone, the brand Airtel or Vodafone become famous. So brand, which is, even if it is related to a new technology or a new product, if the brand is getting protected, you want to protect that brand, that gets protected under trademark. Trademark, that is the mark used in trade for a particular goods or services. In Hindi, we call it Vyapar Chin. So brand, which is related to a name or a logo or a tagline, anything which I look at and identify as a brand. So if I see the logo of Mercedes on a car, Mercedes is not written there, but I can look at that logo and identify, oh, this is Mercedes car, because that logo has created a brand around itself. That gets protected in trademark. Nowadays, even sounds get protected under trademark, because when I listen to a sound, when I listen to a Harley Davidson bike crossing by, even if I have not seen the bike, I can listen to it and identify this as Harley Davidson. So that is protected under trademark. Then whatever work of art anybody creates, be it a movie, be it a painting, be it a graphical user interface of a software, all that gets protected under copyright. The right of my work of art not to be copied is copyright. As is, the expression should not be copied. So any work of art element of a particular product or a particular design or a particular creation is protected under copyright. Now coming to inventions. Invention in its broadest form or broadest definition means something that has been created to advance a particular existing technology or to solve a particular problem. Right? So I invented a new way to segregate my bookshelf. I can use that in general parlance. But in legal terms, what does invention it means something which is technical in nature, which we will discuss further as the session progresses, because I'm going to focus on patents more. Then the aesthetic appearance of a product which is used in commerce, of an industrial product, is protected under designs, which is in India called industrial designs, and in US are called as design patents. We'll also see the difference of patents, design patents a little further in this session. So depending on what kind of element that has to be protected, different type of IPR can be sought and can be implemented in court of law. Now, many startups that I work with in current times have a very, very broad range of intellectual asset creation that they do. They come up with a very, very unique logo to identify their products very easily in the shelf, because every time you can't write the name of the company. So a logo is there which on the shelf can easily tell the customer that, okay, this is the product that I have to buy. This is the product that I saw at my friend's place, so I have to take it. So they come up with unique logos. They come up with unique taglines that we seek trademark protection. Whenever they create a software, now in recent amendments in the copyright regime, software has been allowed under the ambit of copyright in literary work and artistic work. Literary work comes for the software code. Whenever I write a software, the code that is written can be copyrighted, and the graphical user interface that comes in can be protected under the artistic part of copyright. So they come with different softwares, different user interfaces that comes into copyright. Invention, whenever they come up with a technology, patents come into picture, and whenever they have some beautiful design of their product, which most people do for attracting customers, comes under design. Now, in most of the startups that I have worked, I have seen the ones which have very strong patents and designs tend to catapult by attracting a lot of investors. I am not saying that those who don't have are not successful or not famous, but in my experience, having a very unique concept in terms of technical achievement is a big game changer. For example, we saw the onset of e-commerce has completely taken over the business industry and the investor and startup area of the gamut. And also we see that apps and aggregator mobile apps such as Uber, Ola are the ones which have done very well. Then you have e-learning modules which are picking up and becoming very popular. So all of these rely upon certain core technological innovations, core technological improvements, which makes it very easy for the user to access what they need to an online portal. So we've seen a very good number of companies become successful, get the investment due to a proper leveraging of patents. And patents is something which is not very well understood in terms of the technicalities and how to go about it. So I will be focusing, because of limited time available with me, on patents, how to catapult and leverage patents, what patents are, how are they different from other types of IPR, and some case studies along with certain best practices of patent. Because other things, trademark, copyright, designs are not very difficult to go online, read, understand, and even speak to some people. But patents is something which I believe needs extra understanding and extra emphasis, and that is why I'll be focusing on patents. So I will read a very, very famous quote on patents, has been highly subscribed to by patent attorneys, patent engineers over the years. This is one of the first quotes that I heard when I came into the patent industry. Abraham Lincoln very famously said that the patent system has changed the overall mechanism of how innovation and science, technological evolution takes place, because patent system secures to the inventor for a limited time the exclusive use of his invention, give him monopoly thereby, and thereby added the fuel of interest to the fire of genius in the discovery and production of new and useful things. Famous quote by Abraham Lincoln. I will come with another famous quote of patents that we all are more familiar with, where Chatur Ramalingam has very famously said that Funsuk Angdu has 500 patents and the world wants him. And once he signs the deal with my company, I will be huge. And the factor that made Punsuk Wangdu so coveted, and in the end, Chatur Ramalingam had to accept defeat because of his ingenious ways and protecting those ingenious ways through 400 patents, not alone just making inventions, but getting them patented, and that helped him leverage and win the war in the battle of the famous Three Idiots. Right? So, what exactly is a patent? If I take a sort of general parlance and legal definition together, this is what it comes by. A patent is a techno-legal document giving legal rights for a new and inventive technical invention. This is very important. So a new concept for me to organize my table or organize my bookshelf is not a technical invention, thereby won't attract the merit of patent. Giving the owner exclusive rights on the invention, which we have discussed, the right to exclude others, and accordingly making it coveted after. Now let's look at what do I mean by techno-legal document. So I am going to take the example of a very famous product which we all use, and I'm going to read the claim of the patent, which is the legal part of the patent, and I will leave it to you to guess what this invention is, and towards the end I'll tell you what the invention is. So in the method of treating foodstuff, those steps which include generating electromagnetic wave energy of a wavelength falling in the microwave region of the electromagnetic spectrum, concentrating and guiding said wave energy within a restricted region of space, and exposing the foodstuff to be treated to the energy so generated for a period of time sufficient to cook the same to a predetermined degree. Now, for those who have already guessed, very good. For those who have, yes, somebody has already put in the chat box, Yadunan Kamath, if I have taken the name correctly, and Gaurav Gupta, and it is microwave. Now, microwave was quite evident because the word microwave is there, but for many they are not able to guess because it is hidden in this big mumbo jumbo jigsaw puzzle of different words which are there for expressing the technical part of the invention, but also protecting the legal boundary of this invention. So you see that while they have said that it is a microwave region, they have not specified any range of that microwave region. They have used expressions such as for a period of time sufficient to cook the same to a predetermined degree. In the beginning, it says method of treating foodstuff. They have not even said heating foodstuff, right? So treating foodstuff again is sort of broadening the scope of what the technology does, and it is talking about the steps that are there. For this particular invention, we change that to a data storage device, because today what is being stored in USB drive can be stored tomorrow in some other format. As you've already seen, earlier data was stored in floppy, then CD, then DVD, then USB drive. Now we have micro SD cards, which is getting smaller and smaller and more easy. So instead of saying USB drive or a CD drive or a DVD drive, we use expressions such as data storage device or data storing means to be able to capture the technology but keep it legally broad. And that is the essence of a patent document, which has to have this combination of techno-legal protection of the invention. And hence, this sometimes requires a little more understanding and technical expertise. And this is a very old patent that is granted for microwave. Now coming to difference between a patent and a design patent. Now, design patent is a term which is used in the United States. In India and many other countries, it is called as industrial design. We call it patent and industrial design. In US, they call it utility patent and design patent. Even the pronunciation varies. So in US, they call it as patent, and in Europe, they call it as patent. So slight difference in the pronunciation as well. So industrial design or a design patent protects only the aesthetic appearance of an industrial product. Let us take, for example, a chair, which is an industrial product, sold in commerce, sold in industry, made in industrial scale. Now you see three different designs of a chair which have all similar technical features. There is a backrest, there is a handrest, there are 4 legs to support, there is a base to sit. Each of these will get different design patent, but each of these have similar technical features. So only the aesthetic appearance is different, and hence each of these will get, and in fact have gotten different designs, because I have taken these images from design patents that were granted for different chairs. Now let us look at, if somebody had to file a patent for a chair, what kind of technical aspect does that require to furnish to the patent office, and how it is done in a techno-legal format. So this is a patent or a utility patent in the US, as it is called, granted in US 783280 is the patent number, the patent number, and B2 is called as the kind code, which signifies that it is granted patent. The title is lounge chair with adjustable armrests. Now I am giving, with the support of the drawing that is presented in the patent, the language used in claims, which is the legally binding part, which is what the heart or soul of the patent is. A chair comprising. Now comprising is a legal term which says that if something comprises A, B, C, it can have A, B, C and other thing also. So that is a legal terminology, which is called as a transition word, transition phrase. A seat support, a back support attached to the seat supported by one or more first pivots. The first pivots configured to adjust an angle between the back support and the seat support. So here they have created some sort of a pivoting mechanism to be able to adjust the angle between the back support and the seat support, a technical feature. A first armrest and a second armrest, each of the first and second armrest attached to the back support. It defines how the armrests are figuring in the product design. A leg support attached to the seat support by one or more second pivots. So see how the words are being used, one or more second pivots, means 1 second pivot can be there, 2 can be there, 3 can be there, 10 can be there. The second pivots configured to adjust an angle between the leg support and the seat support. So now there is a pivoting mechanism between the leg support and seat support also, and so on and so forth. So in absence of time, I don't want to go into completely read all the claims, but you get the idea of how here the technical contribution or technical feature of this particular chair, where there is a pivot, 2 levels of pivot, and how that is functioning is explained in a legal format along with a drawing, and therefore it will get a patent. Now question is whether it can get a design patent or in industrial design also. Yes, why not? Something which has a technical contribution or can get a patent for its technical features can also have a new design. So the first time this kind of a chair must have been brought into vogue, they would have filed a patent. Obviously that was not there in terms of technical ability, that is why they filed a patent. If they do go and file a design application also, then they can get it because there is no similar design also present in the past. And a design bill will be awarded for the aesthetic or the appearance of the product, and patent will be awarded for the technical concept or the inventive features of the product. So for a same product, you can get the patent also and a design also, but the patent will be given for a certain aspect, which is the technical aspect, the design will be given for a particular aesthetic appearance. So this is important to understand, because when you are creating your intellectual asset, you think that this is only going to get a patent. No, you can get a design also. You will think that it is only going to get a design, but you can see if there is some technical feature file for a patent also, you will get additional protection. Now, a very common question comes in terms of what kind of intellectual asset, what kind of ideas can I get patented, or can ideas be patented, is a very common question that comes. To answer that, I will take you to the Patents Act of India, where section 2(1)(j) says invention which can be patented means a new product or a process involving an inventive step and capable of industrial application. So if your idea meets these criteria, which is it has to be new, it involves an inventive step, and it is capable of industrial application, means it can be tangibly implemented, then why not? Even an idea can be patented, because idea in itself, the word has a very broad framework. An idea could be anything which does not fall under these three categories, or could be something which can fall under these three categories also. If it does fall under these three categories, then that idea is an invention for the purpose of patent, and it can be protected. Let me take an example of what do we mean that, something which is tangible can be protected. What kind of example can I give? So I'm going to take a very famous example of the single click patent of Amazon.com, which really brought it into a very famous sort of framework. That single click patent was granted to Amazon. Very popular case study for the people who want to understand patents. In US, this patent was granted for, I'm reading the claim, a method of placing an order for an item comprising under control of a client system, displaying information identifying the item, and in response to only a single action being performed, sending a request to order the item along with an identifier of a purchaser of the item to a server system, under control of a single action ordering component of the server system, receiving the request, retrieving additional information previously stored for purchaser identified by the identifier and received request, generating an order to purchase the requested item for the purchaser identified by the identifier in the received request using the retrieved additional information, and fulfilling the generated order to complete purchase of the item, whereby the item is ordered without using a shopping cart ordering model. Now, what does this really mean? This is basically an idea of allowing an e-commerce purchase to be done by a single click using previous stored information of the user. Normally, if somebody comes and says, any person would say that this is only an idea. Where is the technical aspect of how this is going to be implemented? But when it was written in this legal format, it was written in a manner that if I were to implement it, what are the different steps, what are different components in this system that I will be using? So I used expression like a client system, information, displaying information, so that it becomes a tangible expression. I'm not just imagining something, I'm going to display that information. Then in response to only a single action being performed, sending a request to order the item along with an identifier of a purchaser of the item to a server system. So when I take this idea, basic idea, and put on paper how this will be implemented, and I use expressions such as server system, displaying information, client system, then it becomes tangible. So if I take an idea which can be expressed in this tangible format on paper, then it will qualify those three criteria, and similar criteria are there in other countries including US, and it can get a patent. Maybe I was not clear. Let me take another example. This is another very famous concept which is being used by us on a day-to-day basis. The inventor is Lawrence Page, also popularly known as Larry Page. This application was filed in January 1998, and later on, the same person who is the inventor was the co-founder of Google, and Google was founded in September 1998. This patent was filed in January 1998. This talks about how this search engine will be ranking the pages and get the relevant page on the top compared to a non-relevant page for a search user to get the correct information or to get a better result of their search input. I'm reading from the patent again. A computer implemented method of scoring a plurality of linked documents comprising obtaining a plurality of documents, at least some of the documents being linked to documents, at least some of the documents being linking documents, and at least some of the documents being both linked documents and linking documents, each of the linked documents being pointed to by a link in one or more of the linked documents, assigning a score to each of the linked documents based on scores of the one or more linking documents, and the processing the linked documents according to their scores. So basically, it is also represented through the figure and explained in the patent further. This is only a small screenshot of the last few pages of the patent. The patent is far bigger than this. It talks about how I'm going to take different website links and see their interlinking and score it based on that and increase the rank. So this is in effect what the Google page rank is very popularly referred to. So again, a basic idea, when I'm putting it in paper in a techno-legal document, I explain it in tangible component, tangible process steps, then that idea is definitely meeting those three criteria and it can be patented. So the answer to whether an idea can be patented is yes, if you can satisfy those three criteria and put it across in a tangible techno-legal language and a format to the patent office. Any questions that I need to answer? If they come, I'll do so. I'll take the discussion forward and now discuss some examples of intellectual asset created by some big companies, which we have all heard of or used at some point in time of life. So I'm taking an example of how intellectual asset is created by companies like Facebook, and an example, a very popular feature which attracted me personally to Facebook when I started using Facebook and I migrated from Orkut to Facebook. Basically, it was the continuous wall and photo tagging. Now, photo tagging, the patent was secured by Facebook. And again, for those who are interested later on, you can pause and read this particular language of patent. Is another example of we not realizing, but when we are using certain products, they've already created an intellectual asset through filing patents, getting those patents registered over the years, and then creating an exclusivity around that particular feature. And that is why a person goes and finds, okay, Facebook is very interesting because I'm able to take a group photo and tag all my friends and they get to know and they can accept it and it shows on their pictures and wall also. So that exclusivity became a big sort of big sort of advantage. Now there is a question from Yadunand Kamath. Pardon me if I'm taking your name wrongly or pronouncing it wrongly. Question is, if Google files such a patent, then why do other search engines exist? Doesn't it violate Google's patent? Very good question, very interesting question in fact. So let me take you back to this particular page and show you the particular language that is being used. There is a linking mechanism identified for page rank. Now, if a competitor of Google or if any competitor of a person who has sought a patent wants to have a similar product implemented or similar idea implemented, he will have to either A, take license from the original patent holder, pay royalty, or B, find some variation in his process or product which does not coincide with the claims of that patent. So if other search engines are finding their relevant search links through some other mechanism, then the search engine can exist. The search engine itself will not violate because Google does not have a patent on search interface or a search engine and finding websites related to the keywords you have put in and showing it to you. The violation will happen if this mechanism of scoring and ranking links for the purpose of search results is used. And if the other person is not using this Either he comes up with some different mechanism or uses or sort of not uses this particular mechanism and focuses on something else, he will be able to bypass the trap of infringement or the net of infringement. Sometimes some people will say that which is one element of here this claim that I can change or I can circumvent so that I don't infringe on this particular patent application. So circumvention studies or non-infringing studies is also something which as patent attorneys we do, that this is a granted patent and this is a product. Is it falling in that category? Is it infringing the claim? If yes, which aspect can I change which can then not coincide with the particular claim and I am out of the bracket of infringement, for which we sit with the client and list on all the elements and look at each of the elements, say, can I change this to something else? Can I change that to something, etc. And then the circumvention happens and the patent is not infringed. The other party will go to court. The court will look at the product and the patent document and see that there is no infringement or there is mapping of features. Thereby, infringement will not be pronounced and no injunction will be given. Or you basically take license from that particular company or individual patent holder and proceed forward. Similar example I will be showing in terms of license. So Bluetooth is a very famous and a strong example of something called as standard essential patents. So once a patent is secured by somebody and it becomes the norm or it becomes the standard in that particular technology. For example, I cannot imagine another mobile phone today which does not have I cannot imagine a mobile phone which uses some other form and does not have Bluetooth. So Wi-Fi share will be there, other things will be there, but Bluetooth has to be there. So this has become a standard for any mobile device that is going to be manufactured across the world. So the patents that are of such nature are licensed in sort of a scheme of proper royalties, which is also called as FRAND, fair, reasonable and non-discriminatory licenses are provided, sometimes by courts, sometimes by their own behest, sometimes by an association of mobile companies, etc. They will then create standards and license it out to each of the mobile manufacturers or each of these technologies which are going to use them as standards. So there then it becomes a standard essential patent. It is given out in bulk license, or if it is an individual, then you have to individually go and seek license from that particular patent holder, and thereby other Google, other search engine, and other mobile phones can be there even if Bluetooth is owned by a certain individual or PageRank is owned by Google. So taking forward this Facebook example also, as I said, simple idea. They created the intellectual asset, they leveraged it, and Facebook files many such patents, Google files many such patents, and they are very good at creating this intellectual assets. Now you think of Google as a big company or Facebook as a big company, but just try to envisage the time when they started creating the intellectual assets, filing these patents. They were a bootstrapping company. They were founded while in college. They were founded by very, very young students or very, very young individuals who just had the passion and the understanding that you have to create intellectual assets. So now I can say that, okay, I cannot compare myself with Facebook or Google because they are biggies, but I should look at myself and say, or anybody who's interested in making it big in intellectual asset creation should imagine that when Mark Zuckerberg or Larry Page were in college, they had the understanding and wherewithal to file a patent for their idea and leverage that to become such a big sort of industry and an empire for that matter. So Bluetooth was another example which I'm going to take further. This is another milestone example, milestone company, WhatsApp. Again, if you've heard the story of WhatsApp, they started from scratch and they became one of the biggest mergers and acquisition news going forward. And they also had created very early intellectual assets by filing patents for their technologies or ideas. Again, those who are interested can pause the YouTube video later and then go to these patents. All patents will also be available online. You can easily go to two websites which I will recommend: Google Patents and eSpaceNet. So eSpaceNet is a worldwide database which gives you very good access to patents from across the world and good translation. Google Patents is a very easy interface to use, which will help the first timers to understand how the patents are written and easy access to the documents. So these are two such databases which you can refer to. And all these, and if you just enter US 8995965 in Google Patents or eSpaceNet, this entire patent will come and you can go through the claims, the description, the drawings, all of that. So another example of early creation of intellectual asset, and the company and the individual made it big further. I'll take you to some closer to example. We all have seen enough advertisements of Lenskart. We've seen how the company has grown from first being only in e-commerce sort of a website, only an online service, to now we have Lenskart shops across the biggest malls in our neighboring areas. Now look at what kind of strategy Lenskart had adopted also. Lenskart invested a huge amount of money and acquired a stake in a startup Ditto based in US for their face modeling technology. Now this is one of the patents that Ditto had filed, and I'm going to refer to this claims and with support of drawings. What Ditto did and what Lenskart then leveraged was being able to have an online display of how the spectacles will look on my face. Now the reason why anybody goes to a spectacle store versus online is to actually try out the spectacle frame or the sunglasses frame on the face and see how does it suit my face, does it look good on me, does it suit my style preference, which was not possible earlier in the online mechanisms. This Ditto patent, which I'm now going to read for a reference, it talks about a system for fitting glasses frames to a user, comprising an interface for receiving images of a user's at different angles. So I am sitting here, I am using the webcam at different angles, my head could be there, and a 3D model of the user will be created, an adjusted 3D model, and then images of these glass frames from the database will be shown on my face, how it will look, and I can see for myself whether this frame will look good and then order if I can. Now this is again written in this technological format. For those who are interested, you can go through it in detail by entering the patent number. I have not given the patent number probably here, but if you go and search Ditto Technologies and this particular title, you will get this. So another example closer to home in India, how a company which had a particular technical challenge identified that intellectual asset can help them leverage that particular technology and provide other additional advantages of online shopping. And it has again made a big story by using the intellectual asset appropriately. Now, going forward, I want to discuss another very important point which a lot of people ask: whether software can be patented in India. We looked at this Ditto technology, we looked at Google, Facebook, WhatsApp, all of those patents, but all those patents you must have noticed I have taken from Google patents are US based companies and mostly are US patents. A lot of people have this concept, confusion or doubt that whether a software can be patented in India, for which the main reason is a section 3K of the Indian Patent Act, which says a mathematical or a business method or a computer program per se or algorithms are not inventions within the meaning of this act and hence cannot be patented. So computer program, business method, algorithms, all of these are software implementations on e-commerce. Can those patents granted? The answer to that is yes, of course, if they meet certain criteria. So if a software meets a certain criteria, which means that it shows some tangible effect or tangible output, then it can be patented. And a recent judgment of Delhi High Court, which further asserts some jurisprudence around this area, and I'm reading from that. The bar on patenting is in respect of computer programs per se, not all invention based on computer programs. In today's digital world, when most inventions are based on computer programs, it would be retrograde to argue that all such inventions would not be patentable. Innovation in the field of artificial intelligence, blockchain technologies, and other digital products would be based on computer programs. However, the same would not become non-patentable invention simply for that reason. And further, there are some qualifications in this particular judgment and some previous judgments, which is a very famous Ericsson case, which explain that even if there is an algorithm, even if there is a computer program, if you can show there is a tangible effect, there is a technical effect, there is a technical contribution. For example, in the case of lens card, we have a physical technical output where I can see how the particular spectacle will look on my face. Now there is no hardware here. It is all happening in my computer because there is an image taken from my webcam. That image is going to the server of Lenskart or any such website, takes the spectacle that I've chosen, maps it through a 3D modeling. This is also a software implemented process, and displays me an image which is also a software implemented process on the screen. This is purely, if you say, a software process or a software output. Yes, the answer is yes, because there is nothing physical that has come actually on my face. But whether it has a tangible output, it has a technical and tangible effect, the answer to that is yes, and that kind of software can be patented. Again, I have taken some examples of a basic keyword search of all Indian patents. These are all Indian patents, which have software element in it and have got granted. For the last few years, I have been arguing many software patents, and we have got many patents granted on this very principle or this very argument. If there is image processing, there is a technical effect. If there is a tangible output, there is a technical effect. If there is a real world implementation, even if existing through a software, it is a technical effect and it is patentable. And we have got several patents granted on that. So software is very much patentable and should be applied at least in the right language, right format. If you can get the expertise of an experienced attorney, if you would like to come to us, we would be very happy to help you and support with drafting in the proper format a software in a tangible and technical effect, showing claims and patent specification, which will help you get that granted. If you want to still try it out your own, you can very well file the patent yourself and see what the patent office has to say. But as I showed you examples of techno-legal document writing, it is always best to consult an experienced patent attorney. Sometimes attorneys which are not into patents but generally talking about copyright or generally supporting in copyrights and trademarks can all help you. But in drafting the patent, you should always take the expertise of a techno-legal expert. Further actions can still be supported by other legal experts, but a technical part should be handled by a technically experienced patent attorney or patent drafter. So these are examples which you can also have a look, pause your YouTube video later and see. And each of these patents can be searched on ipindia.nic.in. There is an access to the patent literature, patent documents there. Now, just as closing comments and giving general best practices on how to go about creating and leveraging your own intellectual asset. You might be at a certain stage of life where you have not really invented anything. You have not created anything. Those who are already inventors, they know how to go about it. They understand how patents can be filed, trademarks, copyrights and designs can also be understood and then leveraged. The next speaker will also be highlighting the significance of trademarks and that is why I'm leaving it to her best expertise to be able to guide you appropriately. And I'm sure that you will get very good ideas from her on how to leverage the trademark and the brand that you are creating. But other than that, if you are observant enough, if you are just looking at different sort of technical problems, the challenges that you face, and you come up with ideas, you can also leverage those ideas to secure patents, as long as you can bring it in a technical framework and implement it through a techno-legal language, and leverage that intellectual asset. And who knows, you will be able to also bring a product out there which has good demand and which can take you to reach sky heights. So first step, which I tell a lot of students, and I interact with a lot of students, of course, when I'm doing an offline interaction, it is more sort of live. Right now, I don't know how the message is being received, how the audience is responding. So I am also sort of limited in gauging the audience and telling them things, but still some of the best practices that I have come up is to first that you have to decide that I will start creating my intellectual asset, be it some content that I create and make copyright asset. If I want to create some brands or taglines, if I take any product, I want to get a name and then make a hashtag around it, make a website for it, make a Facebook page for it. All of that is going to create a brand. You have to first decide that I will start creating my own intellectual asset, and keep looking from your day-to-day life, your surroundings, when you're interacting with your friends, when you're interacting with your mobile, because now mobile is considered to be the best friend of a person, not so much the other friends. So when you're interacting with your best friend, the mobile, you will sometimes face some challenges while looking at certain apps, while accessing certain data. Then that problem, sit and think how you can solve that problem. Write that down on a piece of paper. And that is your first step. That your idea is now ready. Your problem solution idea is ready. Then search on free patent databases, as I said, Google and eSpaceNet, and see if there are other patents around that idea. Now you will be surprised to find what kind of patents are there, and any idea and every idea has some sort of a patent around that area of technology, maybe not that specific idea, but they have been written in a techno-legal format, in a tangible format, and patents have been granted for that as well. Then you will get a basic understanding of how to write it down, how to express it in a techno-legal format, or in a format which a techno-legal expert can understand and draft a patent application for you. Then third step will be to draft a patent application. If you can find a good patent attorney, very good. You can come to us. We will be happy to help you. Otherwise, if you don't want to incur attorney fees, if you don't want to take the trouble of going to an attorney and speaking to them, at least file yourself, but do it. See how the other patents are, draft something accordingly, and go ahead and do it. I have so many clients who, as first-time inventors, filed their own patent application, a provisional specification, which is an initial entry-level synopsis of your invention, and they had messed it up very badly. They had not written good patent, they had not written good specification, and we so wish that they could have come to us earlier. But even then, we are able to take that provisional specification and bring out something from it in the later stages. So after provisional, you can file a complete specification where amendments are allowed. Then there is a prosecution stage where certain amendments can be done and certain limitations can be put on your claims, and patent can be granted. Many such patents I myself have got granted, which were initially drafted by the inventor himself, not in the best format, but still in a format which was workable, and we got a patent for them, and they were able to leverage their idea. They were able to benefit from it, advantage from it. Many professors we have worked with, many students we have worked with, many employees who are working in a certain domain, and then they come up with a certain idea, and if their contract is not violated by that particular patent, then we go ahead and help them with securing a patent. So either a patent attorney or yourself, but do it is the advice. Once start doing it, then you'll understand the process. You'll be making out 2 or 3 mistakes, but the 4th patent, 5th patent will come out much richer, and that could be the game changer for you. Then do file design for aesthetic elements of your product. There is a company, because I was told that this is going to go in YouTube, I am reserving from taking certain names and putting public disclosure of certain information, because all of that is sensitive information. Otherwise, I was going to share some success stories and case studies with you, with people who I have worked with, but I want to refrain from doing that. But I'll just give you a synopsis. A company that I have worked very closely with, again, started by very young bunch of people straight out of college. They created a product which was very useful in rural India, helped a lot of household homemakers, and they filed patent for the technology, but initially had not filed a design for it. So we sort of supported their strategy, and we created a strategy around filing the patents correctly or restructuring the patents correctly, then filing a design also. And those designs we filed internationally also, because design filing is comparatively cheaper internationally compared to patent filing, because every time patent is filed, an examination comes, response is done, all of these things take a lot of money. But designs are comparatively cheaper because you just have to give the images. There's not so much of verbal techno-legal communication that happens, which saves money. So we filed design for them internationally, and that helped them get a lot of contracts and deals internationally, even though they did not file many patents internationally. So that is something which I want to share. Somebody has shared a link of iparena.in. I don't know with what context, because they have not written, so I'm just bringing it out. Please, Suvarna, if you can tell me why you have shared this link and what is the purpose, then I can look at it further. Going forward, on suggestion, I think Suvarna has written, I think it's a service. You can look at it, and if you find it useful, you can take it forward. File design for aesthetic elements of your product. So anything which can be leveraged internationally, can be leveraged as an intellectual creation and can save you money at the same time, is a good advice. Sometimes we see that if a product which is technical in nature, it is also qualifying for design, file a design. For the aesthetic appearance only, but at least for the aesthetic appearance, file the design. Sometimes the design of the product itself contributes to the technical features also. For example, I don't have it with me right now, but you must have seen a tetrahedron massager. Let me just quickly try and show you that. Tetrahedron massager. So you must have seen this in many sports shops. I bought mine from Decathlon, and this is a tetrahedron massager which I just place on my back, press, and it gives me a feeling of massage. Now, the design of this tetrahedron massager is unique, and it has its own visual appearance, but the design also contributes to the technical feature of this invention, that I can hold it from one leg and the other three legs can be pressed on the back, and when it is rubbed, then it gives the feeling of three fingers that are putting pressure on the back. So the design itself contributes to patent. So if I file a design for it and a patent for it and get a design, then nobody else can copy my design. Automatically my technical feature also get protected. So where you can also file design for the aesthetic elements or the visual appearance of your product. Then further, I think obviously this is something which is common sense, but I still want to emphasize on it. Once your patent is filed, you are provisionally capable of exercising that right to send legal notices to others. It is implementable only after patent is published, but you can still inform others that my patent is filed. I can I can also start using the invention because my patent is filed. So my public disclosure will not be prior art for my own patent. Bring out that product, get feedback from industry experts, get feedback from people working in colleges in that domain. For example, anything related to electronics and related domains, Professor Talele will be a very good person to go and seek consultancy or seek feedback from that. This is my product, sir. What do you think with whether this will have good feasibility in the market? Because he works so extensively in the industry as a college professor, and then industry experts, scientific experts. go and study that industry, see how your product can solve a particular problem existing in industry. Sometimes the solution that you have identified is not the pain point of the industry, but similarly that particular feature can solve another problem. For example, very famously, I've heard the story of postage stickers, right? The postage stickers initially was not meant to serve the purpose. It was made by accident. It was for some other thing that was being prepared. It accidentally made like that, and then later on it was found that, oh, this will be useful. That only a small portion of that particular page has glue on it, so it can be stuck on your desks. It can be stuck on your books, and something can be scribbled on it for to-do lists, etc. So your solution or your technical feature can probably find some other underlying problems solution in the industry, and for that you have to go and talk to the industry expert. So they'll say, "Acha, aap jo bol rahe ho, wo to nahi ho sakta hai, but I think this will be useful for my another problem which R&D team is working on," and it takes it from there. Study that market, and then, as I said, jump into action, either part-time or full-time. A lot of people I have seen jump into full-time, but then they go back to part-time. So that is also a good idea. Start part-time and see whether your product is really getting good feedback before starting your own company and taking all the eggs in one basket. But if you're confident, if you're sure, if the product is good, a lot of people have gone full-time and made a big success story, let alone the money, but the impact they have created. Facebook being an example, Google being one example, and some examples in India as well. And so then either start your own venture or collaborate with another company or an industry, or license out the technology and benefit from the royalty. So these are some final thoughts. And in the limited time that I had, I tried to capture the essence of what is intellectual assets, some examples of how some companies have leveraged the intellectual assets, how patents and designs are different, and both can be equally utilized and leveraged by companies. An example of which I gave from my own clientele, they did not file patents in several countries, but they filed design in many countries, and that helped them a lot. And thereafter, in the end, I want to leave with you with the thought that Kunsuk Wangdu is one and only, and is famous because of what he created and patent that he filed. So 400 nahi, ab 4 banaiye, and then see that some Chatur Ramalingam will come and want to sign a deal with you. So that is the concluding remarks. And if you have any queries, any issues, any support required in your patents or any other intellectual property, we also do trademarks, copyrights, counterfeit related activities in our firm. We can support you with entire intellectual property gamut. But since I had limited time and I wanted to focus on patents, I dedicated this 1 hour to patents. And the next speaker will give you a lot of insights on trademark. And I am looking forward to hearing her thoughts and her insights. And with that, I would like to close my session. I've been speaking for quite some time, and since online is that way, one way, I have gotten bored of listening to my own voice such a long time. So I will cease now, and you can reach me anytime for anything, and these are my credentials.
Yes, good morning, sir. It's a very nice session. I am Nagananda here, placement officer at Visit. I just wanted to ask 2 questions.
Sure, sir.
Number one, if a patent is filed in one particular country, can people from another country use it? If it is no, then how do I find out whether an idea or a process or a design is already patented in any of the countries in the world? That is the first question. Second question is, when students are doing project work in the final year, we expect them to publish a paper.
Right.
We expect that they should publish a IEEE paper or some good journal paper.
Right.
And if it is published, if that whole thing what they are doing is published, can it be patented later, or we should apply for patent first?
Okay, so 2 very important questions, and questions which have not been covered in this session but are very relevant to everybody who will ever file patents. Question number 1. If a patent is filed in a certain country, say US, and have not filed a patent of the same technology in India, then whether somebody can use that invention in India, practice that invention in India or not. The answer is yes, he can use it or she can use it, because patent enforcement is jurisdiction specific. When I'm applying for a patent, the novelty and inventiveness will be searched globally. So at the time of filing a patent, my patentability has to meet global standards, that nowhere else in the world this technology is published through a patent, a paper, or commercially, any which way. So patentability is global, but enforceability of patent is local. So only in those countries where the patent is granted, not even applied, the patent is granted, can be enforced in court of law. If it is applied in India, then it can further get granted, and after that it will be enforced in court of law. So you can still be wary, or you can still be concerned that if I launch the product now, 2 years later the patent can get granted. So a pending patent application will not have immediate enforcement, but a pending patent application can have future enforcement. But if you don't have any patent at all in India, then you are free to operate that invention. And for that, to find out what, as you said, how to find out whether you are free to operate that invention in India, you have to carry out something called as a freedom to operate study or analysis. In that, I will look for only specifically patents which are applied for in India, are granted in India, or can enter India in later stage. Because patent filing has a certain period that within 12 months, any person from US will have to enter in India or through a PCT application. और टेक्निकल है, आप अगर सर्च करेंगे तो आपको पता चलेगा PCT is an international vehicle. So या तो PCT live है या इंटरनेशनल एप्लीकेशन का 12 months पूरा नहीं हुआ है तो वो इंडिया एंटर कर सकता है. It can enter India. Or if there is a pending application in India which is still prosecuting, has not been refused, or if it is a granted, if any of these three are done, then you cannot go ahead and practice that invention without taking a license, or without fearing, or without possibly facing a legal lawsuit.
Okay.
To find that out, there are databases. So Indian Patent Office has a database where you can do a search. There are paid databases which we use in a law firm, which give us single window access to multiple jurisdictions. So if I want to find for India, I will put the jurisdiction India, put my keywords, then all the Indian patent application will come in. I will put for PCT last 1.5 years priority date or filing date for US or other countries last 1 year filing date, and see that whether the same technology is there or not. So
the point is, I am given to understand that we should do a local search for which of them are applied for and which of them are granted. And then accordingly,
search, I would not call it a local search. The search is to see the local infringement possibility. Okay. So although it is majorly local, but you also have to search PCT application in other countries, because they have that window of 12 months in which they can enter. So आज मैंने search किया India में कोई है नहीं. I will go ahead and practice that invention. 3 years later, 4 years later, lawsuit आ गया. पता नहीं चलेगा कि अरे patent आया कैसे, because I had searched and it had not come. It had come through the PCT route later after my search.
Okay.
So that PCT window is still open for entering India. So the search has to be with a local infringement possibility, primarily local, but these other countries also have to be searched for a full freedom to operate.
Okay.
So that is part number 1. Second question, sir, if I can ask you to repeat that, sir.
Yeah, the second question was that when students are doing their project work, they are doing something innovative, something different, something this thing. So we force them. We ask them to write a paper.
As a thumb rule, when you have any technical concept, for patents particularly, any disclosure, whether through any public disclosure, whether through a paper, through paper presentation, a seminar, through say a YouTube video, any public disclosure can threaten the chances of your patent, because your own prior art or your own publication can be used against your patent during the examination. at the day of filing the patent application.
Okay.
There are certain provisions, but they are very, very difficult to implement, and they are very, very, moot and subjective. As a thumb rule, as a best practice, you should file at least a provisional patent before publishing your research paper, before giving a paper presentation, poster presentation, before having a YouTube disclosure for how you have, come up with a technical solution to this technical problem. If
So
you
if
want
we,
to,
if so, I am given to understand if we just even file or even if we submit it, then we can go ahead and
yes,
give the presentation.
yes, the day you
Okay.
file an application, you secure something called as a priority date. Means
Okay.
that invention, that technology, that particular claim has that date's priority. Anything that is coming after that date will not have priority. Your patent will have priority.
You know, sir, this is a very, very important, vital information because in that
Correct.
mood to, present my paper and get it published and all that, we miss out on the small little thing of getting that fine niche of getting it patented in the name of the college or name of the professor or name
I
of the
understand.
student who has done it.
And this is a very
Out of over enthusiasm, we just miss this, and then nothing can be done because it's already disclosed.
totally said.
It is
And I
already.
urge that the enthusiasm should be maintained, but it should first be directed to a patent and
Yes.
then to
Thank you
paper
so much.
publication.
Thank you so much for this vital information, sir. Thank you
My
so
pleasure,
much.
sir. Thank you for asking those questions. They are very relevant
Yes.
to the
Thank you.
to
Thank
the
you.
viewers. Thank you so much.
Hello, sir. Hello.
Yes, yes, sir.
Sir, Amay Gadvi speaking.
Yes, ma'am. Tell me.
सर एक्चुअली मुझे सर क्वेश्चन था, अगर मेरे पास कोई टेक्नोलॉजी है एंड वो टेक्नोलॉजी मतलब किसी के पास नहीं, मतलब इंडिया में मतलब वर्ल्ड में किसी के पास नहीं, एंड मैंने वो उसका पेटेंट निकाला, एंड अगर वो मुझे पता कैसे चलेगा कि मतलब किसी ने मेरा मतलब मेरी टेक्नोलॉजी कॉपी करी है, वो मुझे पता कैसे चलेगा?
हाँ, तो ये ओनर हमेशा पेटेंट ओनर के ऊपर होता है कि he has to identify who are the infringers. They can either engage an agency. Sometimes there are agencies who will look for infringement, inform you or take action on your behalf, or you can keep yourself updated of the market trends. You can go to exhibitions. You can talk to sellers and distributors in that particular domain, and you have to keep yourself informed of any possible infringement and then take legal action against that. क्योंकि और कोई मैकेनिज्म है नहीं, वो ओनर्स किसी भी राइट ओनर का ओनर्स उसके ऊपर होता है कि वो अपना राइट एक्सरसाइज करे और जो उसके राइट को इन्फ्रिंज कर रहा है उसको वो खुद आइडेंटिफाई करे. So that is the case in patents also.
ओके सर, एंड अगर मतलब मुझे समझा कि XYZ कंपनी है, वो मेरा मतलब पेटेंट यूज कर रही है, देन मुझे मतलब वो उसके ऊपर लीगल एक्शंस क्या हो सकते हैं सर?
So first legal step is to send a legal notice. Sometimes informally also you can reach out अगर आपको लगता है कि हाँ ये शायद गलती से किया हुआ है और मैं बात करके इसको स्टॉप करवा सकता हूँ, क्योंकि आपका मेन इंटेंशन टू फोल्ड है, या तो उस पर्सन को स्टॉप कराना या तो उसको बोलना कि आप हमसे लाइसेंस ले लीजिए, टेक लाइसेंस फ्रॉम अस एंड पे रॉयल्टी and pay proper amount for using my technology. So for that you might want to start an informal conversation and see what the other person is interested in. If he's saying I'll take the technology or license, then good enough. Then if you can come to agreement terms, then you don't have to go and stop the person by sending a legal notice or going to court. But if you think that the person, you don't want to enter into a business agreement, you want him to stop, then you can send a legal notice. If they don't reply to a legal notice, you can go to court. You can also directly go to court, but if you send the legal notice, it shows that you have acted in good faith, you have informed the other person, and despite your informing, the other person has continued to carry out the infringement. The court will take all these facts of the matter also into consideration while deciding the injunction and compensation, if at all they give compensation. So best next course is कि आप informally पहले बात कर लीजिए. अगर आपको नहीं इनफॉर्मल चैनल यूज करना है तो लीगल नोटिस भेजिए. लीगल नोटिस का रिस्पांस नहीं आता है, फर्स्ट एंड थर्ड लीगल नोटिस रिमाइंडर्स का, देन गो टू कोर्ट. रेलेवेंट ज्यूरिसडिक्शन होता है हाई कोर्ट में, आप जाके ओरिजिनल ज्यूरिसडिक्शन में plain file कर सकते हैं, and you can move for notice of motion to secure urgent relief in way of temporary injunction. थोड़ा technical है शायद सुनने में legal language, but आप कोर्ट में जा सकते हैं और अर्जेंटली कोर्ट को बोल सकते हैं कि आप रिलीफ दें, और अदर पर्सन का जो भी प्रैक्टिस है, अगर वो प्रिमा फेसी केस है कि बहुत क्लियर कट केस ऑफ वायलेशन है, देन कोर्ट विल आइदर टेक एक्स पार्टे हियरिंग कि अदर पर्सन नहीं है और वो इंजंक्शन दे दे, या फिर आपको एक दो हियरिंग में टेम्पररी इंजंक्शन मिल जाता है या प्रिलिमिनरी इंजंक्शन मिल जाता है, and thereafter the proceeding will go forward. You can get compensation also, and permanent injunction भी दिया जा सकता है. So that is the next best step, go to court and seek relief from the court. Is that answer adequate? Does that answer your question? Any other questions? Somebody asked me, so how do I file a patent in terms of software design or something else? And what will be the cost of filing patent? That's also a very interesting question, practical question है. तो अगर जैसे आपके पास कोई software design है, तो design you have to write it in a tangible format. As I showed some examples, you have to break it down into tangible process steps, tangible components of what that software is going to do, how it will bring out a technical effect. So for that, generally, patent draftsmen or patent experts can help you. Otherwise, you read other patents और यही technology या यही features को उन्होंने कैसे reduce किया है in techno-legal format, वो आप पढ़ के उससे inspiration लेके you can use a similar sort of format. But generally, it's better to just go tell a patent attorney that this is my invention, this is my technology, this I think is unique, and he will have an interview with you, ask questions, get a better understanding of the invention, and then write it in the technical format which is acceptable to the patent office, which meets the criteria. And cost of filing a patent, देखिए वो cost में दो elements होते हैं. एक तो government fees which you will be having to pay to the government, which is for the filing of patent and then further amendment अगर कुछ etc etc. And the second aspect is the professional fees that you will be giving to the attorney or the consultant who is helping you. Now attorney fees obviously ranges depending on the level of experience, the popularity and other factors, whatever the attorney decide. So attorney fees तो मैं comment नहीं करूँगा. आप individually अगर मैं mail लिखे तो I will share my schedule of fees with you and we can discuss on that. But publicly I would not like to disclose it. And individually I will be very happy to tell our fees. And government fees में तीन criteria है. एक individual inventor and startup, small and medium enterprise के fees और एक large entity fees. So ये तीन categories में है. Online IEEE.gov.in में आप अगर search करें तो आपको patent के different elements के filing के fees, amendment के fees, when patent get granted उसके maintenance के fees, वो सब एक PDF file में मिल जाएंगे. Generally Google search करते हैं Indian Patent Office patent fees, then I think you should get that PDF, or ipindia.nic.in may you should get that information. So professional fees and government fees, and likewise for other countries also. US का भी आप website में मिल जाएगा, Europe का मिल जाएगा, PCT का भी मिल जाएगा, and then the attorneys of those countries will have their fees to do the filing and the prosecution. So fees is that. You can individually write to me on this email address. I'll be happy to share my schedule of fees with you. Any other questions?
Thank you, Abhishek. It was really nice, and most of the queries are sorted out. If there are something left out, we'll keep in touch with you and we'll inform to the participant. So I request all the participants write your queries on the chat. We will get it sorted out. We'll communicate you by mail.
Thank you so much, sir. And I'm sorry थोड़ा सा मैंने time extend कर लिया. I think थोड़ा सा overreach कर दिया मैंने time का, and apologies for that because the other speaker.
Perfect utilization of the time and podium.
Sir, welcome. I would really like to welcome the next speaker and listen to her sessions.
Garima?
Over to you and over to her, sir.
Yeah. Siddharth, can you please present the presentation?
Thank you so much, sir. The attendees have immensely benefited from your knowledge and case studies that you have shared. We express our heartfelt gratitude to Abhishek Pandurangi for his valuable time and insightful presence during the IEEE Entrepreneurship Bootcamp. Thank you, sir.
Thank you. My pleasure.
Now that we have a brief understanding of what intellectual property is, it is important to secure your intellectual property to move ahead with your business. After the enlightening session on how to create an intellectual asset and all about patents, we would like to welcome our speaker, Sia Lala, for our last session of this journey on trademark and copyright.
The founder and managing partner at VAL and Associates, Sia is a qualified company secretary from the ICSI, law graduate and postgraduate diploma in business management, has done is a law graduate and a post diploma in business management from Mumbai University. She's a corporate and commercial lawyer, also the founder of VAL and Associates. Ma'am, we heartily welcome you to the event and kindly request you to address the audience now. Over to you, ma'am.
Thank you so much, everyone. And it's indeed a pleasure to come here to speak to each one of you. And thank you so much, Abhishek. It was wonderful hearing you. While you stated that it's that you bored hearing yourself, but trust me, Abhishek, it was pleasure hearing you, and I'm more than happy to have you here. Abhishek, as you all know, is also a trademark and a copyright attorney. Abhishek, please feel free to provide your insights in terms of what your views are. And I'm more than happy to collaborate and work, have this session with you. So yes,
thank you so much. That's really, really gracious of you.
Yeah, please feel free, because I think at the end of the day, we're all, we're all professional, and as much as value add that we can really give to the audience is what we are really looking at. So please feel free to give your suggestion, guys. Abhishek himself is also a trademark and a copyright attorney, a very experienced professional. So please feel free to have us both, for this session. So yes, with that, I'll start my session. Can you go to the next slide? Am I supposed to present here, or are you guys going to be presenting the?
I know it would be better that you present it. Just click the share screen there.
Yeah, I'll do that.
Yes.
Yeah.
Just go.
Yeah. Okay. So let's quickly start. So in terms of our understanding today, after what you've understood from Abhishek in terms of what patents are, see, when we talk about intellectual property rights in itself, it's a massive topic. It's a topic which has patents, it has trademark, it has copyright, it has got designs. Okay. So when we're talking about trademark, relatively, if you were to see, having understood patents, well, you'll understand that trademarks are relatively simpler in terms of understanding what they are. And even today's presentation, I've tried keeping it as simple as possible, because I really don't want you to get confused about this concept, because these are concepts, while I understand they're not as simple as we speak about it, but they're not as complicated. It's more of a logical, if you ask me. So let's start understanding what trademark is. So trademark, when you're talking about, it's typically a name, a word, a phrase, a logo, a symbol, a design to a certain extent, image, sound, or a combination of these elements. So now you will say that, okay, you've understood it has name to it. There are certain combination of words that we talk about. It phrase. Sometimes it's the phrase that we talk about. So let's not get too much confused here. As we proceed in this presentation, we're going to see what it is, because by way of an example, you will understand it better. Okay, so see, you need to understand that whenever you are talking about a trademark, this is a concept which can be registered. So if you have a trademark for yourself, it is something that you can actually go and register for yourself. And when I say registration, there is a formal application process that you will do when you want to apply for a trademark. Always understand that, you know, you would have seen certain marks having these, having these symbols. Some symbols are like TM. You know, sometimes you would have seen a word, and then there is on the right hand side top they write the word TN. Okay, sometimes they use the word R, and you can see R is written in a way that, you know, it's mentioned as R and then a circle to it. Now, what does it mean? That becomes very important, because it's important to understand what does these small marks mean there. Now, TM means it's a mark where an application has been done and it's still a work in progress. So typically you would see a trademark does take some time. So here as well, when you're talking about a TM, it's a mark where an application has been made and this is still unregistered as we speak. Now, whenever you see the symbol R with a circle around it, it means it's a mark where the application has been made. It has gone through the entire process of what it should take for a mark to be registered, and there is a registration which is obtained. And hence, when you see this term R or the alphabet R, it means that the mark is registered as we speak. Now, this is where I wanted you to understand what trademark is, and hence while we spoke about name, word, phrase, logo, symbol, design, this is how your trademarks will typically look. And this is a few of these common, see, you need to understand that every business works on a goodwill, okay? Today, when I talk about Amul, so if I say, oh, I purchased an Amul ice cream or an Amul butter, there is a significant goodwill that Amul enjoys in the market. Now, when you are talking about goodwill, it is something which is achieved over a period of time. It's not something that one fine day a brand comes and it gets to the level where Amul is today. Now, this entire process that it takes for a brand to reach where it is, there are certain associations which are created with that. So when a brand is in its way or it's doing its journey, there are certain association with certain names, certain image, certain taglines. And these images, you know, today when we talk about chocolate, a lot of time we are not talking about chocolate. We talk about Cadbury, you know. So if I were to ask a child, you want a chocolate, what will I there are a lot of times when we say, oh, you want Cadbury. So because now Cadbury we know is a brand, but it has kind of got it's got, in my mind, it's become similar to what I can call it as a chocolate. Similarly, when the brand in its journey to reach where they want to reach, the associations which are created by certain marks, certain words have to be protected, because people start identifying the brand with these marks, with these words. And hence, it becomes very, very important that these marks or words have to be protected. And how are they protected? They are protected by way of a trademark. Now, similarly, if you look at LG, so the moment somebody shows you the mark, you'll know, okay, yeah, they're talking about LG. Similarly, for a Starbucks, okay? So why it becomes important to protect these marks? Because people start associating with these marks. You know, people start, collating the quality, the service, and everything with these marks. And if you don't protect these marks, it becomes difficult, because then there are a lot of people who will go out and do some kind of, whatever they want to do in a way that they would want to grab those brands or want to grab those images with you. And hence, it becomes very, very important that whatever marks that you have in terms of your, in terms of the words that you're using, in terms of the design, the logo that you've done, and this is a perfect example of what you see. You see how Amul is there, and then how it's appearing in terms of the color combination and a lot of things. So that becomes an identification that people start doing with the brand. Now, when we're talking about a trademark, the first thing that we need to understand is that, and whenever, so today, if you come up to me and you say that, okay, listen, we have a mark. My first request will be that first, let's go, before you actually start using it in terms of branding and going around marketing that brand or whatever mark that you have in hand, the first thing that you need to do is first go and check if it's available or not. Okay. You need to understand that the IP office and MCA, they both have collaborated. So the moment you search a brand, they are going to also perform a search. In fact, now, because we do the company incorporations as well, the moment you put a name and the moment you run a search, it will, so if there is a trademark which is registered in that name, you will see that the both offices have collaborated, which means that if there is a company by that name also, you will not get a trademark. Okay, so before you actually finalize a mark, or before you actually start putting any efforts in using that mark, please remember that you go and do a basic search, a public search, to see if there is a mark which is existing or not. And if at all, if there is a mark, then obviously you know that you're not supposed to use it. So public search is first thing that I always advise, that do that before you actually start investing any time in doing anything on that mark. So I've actually given you a link where you can actually go and perform a public search for a trademark, and this helps because then this tells you whether you should go ahead or you should just look for another mark. Okay, now you need to understand that there are different types of marks. There is a product mark, a service mark, collective marks, certification mark, and a shape mark. I'm not going to get into this at this stage because with each, for each mark, there is an example that we are going to be talking about, and let's just talk about it with the example. A product mark. A product mark is similar to a trademark. The only difference is that it refers to trademark related to product or goods and not services. So you need to understand product mark means a mark which has got, again, you need to understand that the gist of trademark is certain association with a brand that it is connected with. But within trademark, there are different types that you'll have. Product mark, association is with the product. So when we're talking about product, we're definitely not talking about the service per se. Service mark is what is a perfect example is Google. Now, what is Google doing? It's giving us services, right? So service mark is same as trademark, but instead of a particular product, it identifies and differentiates the source of a service. Okay. Collective marks. Now, collective marks means a mark which comes under an umbrella, which is like, Tata Sons. What are they doing? There's multiple services and products that they are that they're doing. So similarly, when you talk about Reliance, so when you are talking about collective mark, it's one mark that we have towards the top. So these are trademark used by a group of companies and can be protected by the group collectively. And this is very, very common in a big setup, in a group that they have, because they want to ensure that for everything they don't have to go for multiple trademark application, rather they do a group or rather a collective mark which is protected. And when we say something like Tata Sons, we know it's a massive group that we have. Certification mark, as the name would suggest, this is basically a mark that gives you about, or is talking about, the quality of goods and services. Okay, so it's a sign indicating that goods and services are certified by the owner. And you need to understand one thing here, that these are marks which are basically subject to a certain certain certification, like, or certain due diligence. So whoever is using these marks or is assigning these marks to a certain product will do a certain due diligence. It's not just by mere fact that if there is a mark that we have, that it means a quality check has been done prior, before such marks have been assigned to a product, because then there is a different authority who would check the quality and all of that for a particular product. So it's a sign indicating that the goods or services are certified by the owner of the sign, so in terms of its origin, material, quality, accuracy, or other characteristics. Now, shape marks. Okay. Now, you need to understand that shape marks are something when you are talking about protecting a particular shape. Okay. So a trademark may also include the shape of the goods, that is their packaging sometimes, so long as it's possible to graphically represent the shape clearly. Okay, now you need to understand that, see, I've put this example here where we're talking about a Coke bottle in a certain way, or a Kit Kat chocolate that we do. So these are shape marks, or you could have, you see these certain vehicles that we have. Again, we need to understand that there is a slight distinction between protecting a certain design and putting it in under the category of it being a design or it being a shape mark. Okay, so again, as I said, that to certain extent, yes, we can also we can protect our products from for their shape that we have in hand. Now, patents, I don't, patents, Abhishek has spoken much in details in terms of how and why patents are significantly different than what you talk about trademark, as we know, right? So patent is something which is only and only applicable for things which are absolutely new. So if you ask me that, okay, listen, I want to patent this bottle, can I do that? No, because bottle or something which is like a container which has water in it is a concept which is already existing. A different shape to it, yes, I can do it by shape mark. I can protect the shape. But can I say that I will, with my kind of bottle, nobody can have another bottle created? Well, they can have it in a different shape, because as I said, right, patent is something which is absolutely new, something which was not existing prior, right? When the pen as a concept came in, they were subject to patent because that was a new concept then. But today there are different types of pens that we have in market, right? So you can protect these different types of pens that you have, that somebody cannot copy the shape that you've given it. But can somebody not produce another pen in a different form or a different shape? They can, right? Because then it's no longer a subject matter of patent there. Okay, so let's see what these patent marks are. These are marks consisting of a patent which is capable of identifying the goods or services as originating from a particular undertaking and thus distinguishing it from the other undertaking. So patent, as I said, Abhishek has spoken in detail, so let's not get into there. Now, sound marks. While I couldn't put a clip, but sound marks. Have you seen this Dharma production films? You know, there is this particular music that's played when a Dharma production film. So be it any Dharma production film, you hear that music. It's a music that runs, I believe, for a minute or something. So that is a sound mark, something which is identified with Dharma production. So the sound that plays in the advertisement becomes so well known that when people hear it, they immediately know what product or service it refers to. In such cases, the sound may be registered as a trademark and is eligible for registration. So sound mark is something, again, as I said, right, any kind of association that is developed with product or service, it is, the businesses are encouraged to protect that association. Now that could be a mark, a design, a logo, a sound, or something that they're seeing in terms of how that shape of the product is. All of that has to be protected, because as I said, people develop that kind of correlation, or people develop that kind of thought process with these things. Now, registration of a trademark, as we speak, as I said, the first thing that you need to do is to actually go and do a public search. Once you are satisfied with the public search that yes, there is a mark which is existing, you go and you then make an application. The moment you make an application for a trademark, you enjoy the protection of putting TM, which means it's an unregistered mark. It's a mark which tells other people that this is a work in progress, and that if everything goes fine, this is a mark that will belong to the person who's actually made the application. Okay, now time required for registration, if you ask me, this is something which is generally a time driven process, and obviously with COVID we have experienced that the hearing dates and all of that has taken a lot of time. So yes, it is something which is time driven. Because why is it time driven? Because it is open for inspection. It's actually open for other people's to raise objections. If there is an objection, then there is a process that has to be followed. Then there are hearings that are given in terms of making your representation, and only after all of that will you get your mark. Okay, a registered symbol, we know it's something which is indicated with alphabet R, and this actually means that the symbol is registered. Okay, validation, once registered, a trademark will be valid for a period of 10 years from the date of filing, which obviously can be renewed, and obviously you will get an option to get that mark provided you have ensured that the timely renewals have been performed. So if you miss out on a renewal and then somebody in between comes and is obtaining that mark, obviously you will not get the right. So as far as renewal is concerned, it's very important that you get the renewal done in the time frame that's been so decided. Now, list of well-known trademarks that we know, and we've just put the names also. Again, just for you to know what it possibly can look like when you're talking about 7 o'clock, which is for the shaving razor. There is a proprietor that we have there. Then there is Bajaj, which is the word mark here, which is owned by Bajaj Electrical Limited. Then Bisleri is another one. Dr. Reddy's, which is for the Reddy's Laboratories, and Honda obviously is something which belongs to Honda Motors. Okay, so as I said, right, that there are these well-known marks that we have here, and this is more from your understanding that you know that these marks are something which are now. Can I just go and get myself a word like Bisleri? Can I do that? No, I cannot, because it's already it's already with someone. So this is something that you need to understand, that for a mark which is already registered, we will not be able to get them. Now, the one very important thing that a lot of people miss out is that you need to understand that trademark is your class specific. So when I say class specific, there is something called as NICE classification, which basically talks about the various classifications that we have as far as trademark is concerned. Now, suppose I have registered a mark, say in class 35. Okay. Now you want to register that mark, and you want to register it in class 35. Can you do it? No, you can't do it, because I have taken protection of that particular mark in that particular class. Okay, but suppose I want to register a mark but in some other class, but you need to understand that each class has a bifurcation. So suppose if it's a service class, then it has to go only in that mark, okay, or in that particular category. So you need to understand one thing, that your protection will be ensured that it's done, provided you get a proper classification done here. And I'm sure Abhishek will agree in this point that a lot of people are confused here. Like, a lot of people come to me and they say that, no, let's just do it in some other class. And I tell them that each class has a significance to the service or the product that you have. There is absolutely, it absolutely makes no sense, if you ask me, that if you were to do a service and then you go and register yourself in a manufacturing class. So getting the right class for the service or the product which is associated with that mark becomes very, very important. Okay. And remember,
totally agree. You asked whether I agree. So I totally agree with that. And in fact, there have been some instances where, because of the wrong class in the court, they could not get the other party to stop, because they had not taken proper class into picture. So that's very valid point that you brought up.
Yeah, and here this is where we as professionals come in to help, because a lot of time people feel that they can just go and decide the category for themselves. And this is where I always tell people that just read each category and just see where your product or service falls, or where you are closest to in terms of your products and services. So accordingly, the category or the class can be picked up, and that becomes very, very significant here. So procedure, I think we've spoken about it in terms of what it is. It's about doing the initial search here. Once you're satisfied with the search, then decide whether you'll do the mark. Once you decided for yourself that yes, this is the mark that I want, then go to NICE classification. NICE classification is basically a document which provides you all the bifurcation in terms of the 45 classes that we have. That NICE classification is going to tell you which class you have to apply. Now here you need to remember that as many classes as you protect will, that's a beautiful thing. But remember one thing, that each class has a fee scope. So suppose if you were to make an application in say 2 classes, okay, I'm giving you by way of an example, say class 8 and class 35, then you will have to pay government fees, or the fees which is paid with the trademark office for 2 classes. Okay, now you need to remember one thing, that if you are an individual, there is a different set of fees that you're payable. If you're making an application in the name of a corporate, there is a different set of government fees that's payable. But if you are a corporate, and if you have managed to get a startup recognized, if you are a startup recognized under DIPP, you get an exemption of 50%. So if you are a so suppose like currently the fees for a company to make a mark for one particular class is 9,000. But if you are a company, either you are a startup or you are a MSME registered, both, you get 50% off on the government fees, and that automatically makes your cost, the government filing cost, half. And I'll give you an example. I had this corporate who came to me and they wanted to make 8 trademarks. 8. They came to me and they said, this is where it is, and obviously the from a 8 trademark, the cost of 9,000 per mark is what it was coming. So 8 into 9, and that was my advice to them, that they were startup. So I said, why don't you just apply for a DIPP, get yourself registered. Once you have that, automatically your government fees goes down by 50%, and that is something that you will save on from not paying an additional government fee. So remember that if you are a startup or if you are an MSME register, you will have to file those certificate, and you get half the government fees. From a payment of fees is concerned, you get 50% discount on that. So that's something which you need to be mindful about. Okay, then examination, and as I said, right, that the marks are open for examination. People who have objections can raise objections. You will receive objection notices. Then there will be, you'll have to attend to those objections, and then there'll be hearing dates as well, and you'll have to attend to those hearing dates. And when I say you'll have to attend, which means your attorney will go and make a representation before the relevant officers. Obviously, now all with the entire COVID ongoing, the hearings are happening, through the online mode. And yes, it is taking slightly more time as it would take otherwise, because now the hearing dates are coming very, they're taking a lot of time, because obviously there's a massive reach, and then obviously they're not completely operating. It's just few inspectors or few people who are sitting in their offices who are taking the hearing. Trademark publication, and then trademark registration. So if there's no opposition which is received, then the trademark is registered. Now, as far as filing is concerned, there are certain things that you need to be mindful about. You need to first decide whether you need to have mark in your name or you want to have it in the name of a company. Remember, this becomes very, very important, because then that's the name that you'll put as far as the applicant name is concerned. Address is going to be either your residential address, or if you are putting the company's name, then you can use the registered office address here. Then there are certain, sales figure on the letterhead. Now, see, sales figure on the letterhead and all of that is when you want to say that your mark is existing. So suppose if there is a scenario where you've been using mark for last 2 years, and so which is called as, there is an existing user advantage. So you need to make an affidavit. If you are using a mark, and that mark has been used for say last 2 years, and you want to tell the authority that you've been using the mark, obviously that gives them a more that gives you an advantage that you will get the mark in your name, provided you establish this, provided you establish this to the authority on an affidavit that you've been using the mark for XYZ number of years, and hence you should get this mark. So whenever you're talking about these affidavits, you need to remember these affidavits have to be placed in a way where you can establish, in terms of giving a sales figure, your invoice and all of that, to tell them that you've been using the mark for a long time now. Term trademark, the term of protection. So you need to understand that as far as the trademark is concerned, you get a direct protection for a period of 10 years, and thereafter you are subject to renewal. If you happen to renew it, well and good. As I said, your timely renewal becomes very, very important here. So with that, I have spoken about trademarks, and Abhishek, if you wish to add anything to this, please feel free to do that, and thereafter we can take questions.
I think you've quite covered extensively, Sia. So, and then some very insightful points you gave about the class, and I think that would be very useful for the users. So I think everybody can sort of take that cue from Sia, that identifying the relevant classes is quite critical, and that will have a big impact. So thank you for sharing that and putting emphasis on that. Yeah, thank you so much.
Thank you so much. Thank you so much. So with that, we can open up for Q&A. Anybody, any question?
Ma'am, I wanted to ask you, can this process be handled by a startup themselves, or you need to appoint a attorney or a professional agency for that?
You will need a trademark attorney. You cannot make an application without a trademark attorney here.
Sure, thank you.
Because the moment you apply, they'll ask you for a trademark attorney name or a number. A registration number is what they specifically look at.
Sure, ma'am. Thank you.
Anyone, any other question?
Ma'am, we have a question in the chat box from Suvarna. She's asking, how long does it take to get the trademark?
We generally, Suvarna, it's very difficult, honestly, to tell you the timeline, but it takes time. Now, with COVID, I have seen a time where it's actually taken, close to a year's time. Because as I said, right, the trademark offices are not operating in full capacity. The hearing dates that we would otherwise get it in a month's time are now taking like 3 months' time. So this is generally a time process, a time-driven process, and I would think that this should take somewhere like at least a year is what I would think. At least that's with my experience that we've seen that it's going that long. Any other question that we have in the chat box? I am not able to see the chat box anyways. Yeah. Yeah.
If any attendees have any questions, they can either add it in the chat box or unmute themselves.
Garima, what will you do? Many questions will come because everybody wants to go for patent and trademark.
Yes.
Many questions will come in YouTube channel also. We'll club all those questions. We'll try to answer and we'll take the consent of the speakers and we'll communicate to the speaker or the participants later on. So you can conclude the session.
Okay, sir.
Thank you.
Thank you so much, ma'am. The attendees have immensely benefited from your presentation. Siddharth, can you please present the slides? We express our heartfelt gratitude to Sia Lara for her valuable time and insightful presence in the IEEE Entrepreneurship Bootcamp.
Thank you so much, everyone.
So we request Abhishek and Madam Sia to be there with us for the next 20 minutes. We want to request you to be a guest of honor for the validative function.
Now we kindly request Professor Kiran Talele to brief the audience about the last activity of the bootcamp, that is creating intellectual assets.
Okay, I just want to tell you that I'll just mail it to everyone, those who are attending it, because this will be very short time to speak it on this activity. Okay, but I just want to tell you that you take any one patent and just do the review of that patent of any interest of any topic of your interest and just see what is the content of that, and then for just try to be familiar with the patent. So the format and everything will mail it to you. You download one patent, as Abhishek sir has mentioned, from the website, Google Patent or Free Patents Online, and take any patent, just go through it and try to understand it and just make a review report on it. That's the activity. Thank you.
I was about to say that how is that Kiran sir is not giving his inputs, because I know for sure that he has massive knowledge about patent. Obviously, I feel is his favorite topic, and trademark. Yes, so guys, you can please feel free to reach out to Kiran sir. He has very good knowledge about patent, trademarks, and he's really helpful that way.
So just to add to it, I just want to say that
you have also filed patents and you have prosecuted them.
Yes.
Yeah.
Every time I meet Talele sir, he gives me, I really appreciate his enthusiasm on the subject. Like every time I meet him, he's like, what, madam, I've done this, I've done that. And I'm like, wow, sir, this is excellent. So I think he has got massive knowledge, and I always appreciate sir's enthusiasm on
Just
what
to add to that, I just want to tell that I'm starting Innovation Gallery,
Yes,
open
told
for
you.
all the innovators across the country. And we'll connect it, we'll create their IPR through your association and both of you. And we will connect it to the industry for commercialization as well. Open to all.
Thank you so much. Thank you so much, sir.
That is a very much required initiative for commercialization, because a lot of people have got good ideas, they file patents, even they've got patents granted, but they do face a lot of challenges when it comes to taking from patent to market. So I think that's a very good initiative.
And we do have very good contact with others. We have Naman Foundation, founder Mr. Dinesh Sani also joined with us, and we will work in a team and we will help every innovators whatever the way it is possible. Thank you so much. I request volunteers to continue with the next part.
Thank you, sir. Thank you so much.
Thank you.
Yeah,
Thank you, sir.
Before we move on to the valedictory function, we would like to announce the results of final quizzes conducted yesterday, that is quiz 9 and quiz 10. So the winner... Yeah, go on, very much. Sorry.
Sorry. The winner for quiz 9 during the IEEE Entrepreneurship Bootcamp 2021 is Snehanjali Das. Congratulations, Snehanjali.
And the winner for quiz 10 during the IEEE Entrepreneurship Bootcamp 2021 is Ruth De Silva. Congratulations, Ruth. RTS, congratulations for both of you to win for winning the quiz.
We hope you all had a valuable and amazing experience. The feedback form will be circulated shortly. Kindly make sure you completely fill it. We now move on to the valedictory function to conclude our event. IEEE Entrepreneurship Bootcamp 2021 was launched by IEEE Bombay section to trigger the entrepreneurship bugs in the minds of young budding professionals. An activity-based learning is the key point of the bootcamp, with relevant influencers sharing experience in startup businesses. Sessions impact is when the participants hear success stories of successful entrepreneurs.
With this thought in mind, we launched IEEE Entrepreneurship Bootcamp 2021 jointly with Sardar Patel Institute of Technology, Mumbai, Vidyalankar Institute of Technology, Mumbai, SANDIP Institute of Technology and Research Center, Nashik, Naman Angels India Foundation, and Naman Angels India Foundation. The large-scale promotion of this event has helped us herald 4,400 registrations from different cities and states around the nation. A total of 4,050 students, 248 faculty, and 92 professionals registered for IEEE Entrepreneurship Bootcamp 2021. The bootcamp program was a mix of training sessions on entrepreneurship, fireside chats, heart-to-heart talks, inspiring founder speech by successful startup founders, and activity canvas.
The event was officially started by the virtual ribbon cutting ceremony by Mr. Rahul Chari, founder and CTO of PhonePe, followed by the opening remarks by Dr. B. Satyanarayana, chair of IEEE Bombay section and scientific officer at TIFR Mumbai, where he noted that advances in technology for the betterment of humanity is the tagline of IEEE that has come up very well in this work, as no matter what we innovate, the ultimate beneficiary is the common man. Mr. Anand Gharpure, chair-elect of IEEE Bombay section, declared the beginning of the Entrepreneurship Bootcamp 2021. Dr. S.T. Gandhi, Dr. Vikram Patel, Dr. Saurabh Mehta, Mr. Abhay Fansikar graced the audience with their presence.
On day one, the session started with a keynote address of Mr. Rahul Chari, founder and CEO of PhonePe. He stated that entrepreneurship can create social and population-wide benefits. Ms. Rena Tandon, POSH specialist and thought leader, spoke about how we were on that first pedestal and want to win on the edge and create the right image to crack one's entrepreneurship journey. On learning all about napkin pitch from Jutika De Cruz, the participants then proceeded to perform the activity of the day, that was to create a 30-second self-introductory pitch.
On day 2, Mrs. Neelam Kathi Ma'am, Assistant Director of Bharatiya Vidya Bhavan, started the first session focusing on the topic needs and wants, followed by a session of Pravan Chavre, co-founder of VMOSA, who explained about his own startup, God, that is Guruji on Demand. which is platform to book rituals in simple steps.
On day 3, Mr. Dinesh Israni, founder director of Naman Angels India Foundation, explained about the common pitfalls which you should consider and look out for initially before starting any startup. The next session was by Mr. Sahil Bhuge, student entrepreneur, fitness freak, which gave insight about his startup and motivated all the participants to be an entrepreneur.
On day 4, Mr. Vikrant Potnes, founder of Ford Mega Private Limited, gave a comprehensive understanding about a business model and gave various major points on why startup failed. The next session was by Mr. Pankaj Sikka, who gave a talk about startups and stated the 4 P's essential for a startup. That are permission, planning, practice, and most importantly, perseverance.
On day 5, Chandraban Singh, Chief Operating Officer at Sardar Patel Technology Business Incubator, focused on the importance of business plan, followed by a session on Fireside Chat by Aparna Mishra, founder editor of Women Shine and business coach and mentor, where ma'am spoke about her journey to start her startup and how she overcame all the hurdles. Dinesh Israni sir conducted an activity on making a business model and writing a business plan for the idea that we had in our minds.
Today, that is on the last day, day 6, we had a session regarding the intellectual asset creation and all about patents by Abhishek Panduranga and another session regarding trademark and copyright by Sia Lala. Creation of intellectual asset was the assigned activity of the day as briefed by Professor Talele. During the last 6 days, there were varied activities which were conducted starting from understanding our inner self and putting it in a video to penning down our needs and moving to understanding our wants. A case study was done on the journey of an entrepreneur of a local company from zero to hero. Finally, a B model was made for our idea and a formal B plan is documented.
An IEEE quiz was conducted on all days of bootcamp to encourage active participation. The first person with the maximum score was declared as the winner and will be awarded with exciting prizes. The winners of the quiz are from different parts of India.
For quiz 1, we had Ritika Nerkar from Nagpur.
For quiz 2, we had Milin Dande from Goa.
For quiz 3, we had Arpita Ghosh from Kolkata.
For quiz 4, we have Yash Upadhyay from Mumbai.
For quiz 5, we had Chelsea Paul from Indore.
For quiz 6, we had Saharsh Pamecha from Chittorgarh, Rajasthan.
For quiz 7, we had Sradniksha Sitaram Devlekar from Mumbai.
For quiz 8, we had Vishwajit Vilas Rao Deshmukh from Latur. And for quiz 10, we had Ruth De Silva from Mumbai. Congratulations to all the winners.
Anything is possible when you have the right people to support you. We take this opportunity to thank IEEE Bombay section for their constant support in helping us organize this event. Siddharth, can we please move on to the memento slides?
We express our heartfelt gratitude to Dr. B. Satyanarayana for his valuable time and insightful presence during the IEEE Entrepreneurship Bootcamp program. We also thank Dr. D. Suryanarayana for his valuable time and insightful presence during the bootcamp.
We express our heartfelt gratitude to Mr. Anand Gharpure for his valuable time and presence during the IEEE Entrepreneurship Bootcamp.
We express our heartfelt gratitude to Mr. Abhay Phansikar for his valuable time and presence during the IEEE Entrepreneurship Bootcamp.
We express our heartfelt gratitude to Dr. B. N. Chaudhary for his valuable time and insightful presence.
We express our heartfelt gratitude to Dr. Saurabh Mehta for his valuable time and insightful presence during the IEEE Entrepreneurship Bootcamp.
We express our heartfelt gratitude to Dr. S. T. Gandhe for his valuable time and insightful presence.
We express our heartfelt gratitude to Dr. Vikram Patel for his valuable time and insightful presence. We express our deepest gratitude to Professor Kiran Talele, the General Chair of IEEE Entrepreneurship Bootcamp 2021, for his amazing and meticulous direction, without whom this event would not have been possible.
With the constant support of Mr. Dinesh Israni, Program Chair at IEEE Entrepreneurship Bootcamp and the founder of Naman Angels India Foundation, at every step of this journey, this event has found its grandeur.
We thank all the coordinators and our associate partners, without whom this event would not have been possible.
Professor Sakina Salmani from Sardar Patel Institute of Technology.
Dr. Gayatri Fade from SANDIP Institute of Technology and Research Center.
Dr. Uday Kashit from Vidyalankar Institute of Technology.
Professor Srihari Kataukar from Anna Saheb Dange College of Engineering and Technology.
Mr. Chandraban Singh from Sardar Patel Technology Business Incubator.
Mr. Jagdish Patel from SANDIP Technology Business Incubator.
Mr. Dinesh Israni from Naman Angels India Foundation. And lastly,
Mr. Samir Sheikh, the consultant and startup mentor for our program.
We thank all the student coordinators and volunteers for their dedicated time in making this event a grand success.
We express our deepest gratitude to all the participants for their consistency, vigor, and active involvement in all the sessions and activities of IEEE Entrepreneurship Bootcamp 2021.
We would actually love to hear the experience of the attendees from the ones present in the meeting. We now open this platform for anyone who wishes to share their thoughts. Please feel free to unmute yourself or comment in the chat box. Is there anyone who would like to share their thoughts?
I would like to say something. I was always skeptical about how entrepreneurship would, help me, and will it be my cup of tea? But this seminar, this workshop has cleared the fog out of my mind and made my path very clear. All the nuances that I was which were not known to me, this workshop helped me in that. So I thank all of you for this workshop and this informative session. Thank you.
Thank you. We have a few feedbacks in the comment section. Yadandana says, thank you for the amazing experience. Ruth mentions it was really amazing and informative session. Thank you so much for arranging this camp. We also have Pradeep sir saying very nice and informative sessions with expert speakers. Nice to be part of you. We have Suvarna from Goa. We have a startup in education sector. It was an amazing session, very informative, and a lot of pointers for startups to consider.
Nagananda here. I thank you very much for this lovely session for 6 days, and step by step, each day, step by step, we have progressed and got a lot of inputs. Overall, it will help not only the students, also the faculty who have attended to guide the students definitely more confidently and more, I would say, quantizable inputs can be given. And great being a part of this sessions, and definitely I have become very rich in experience. Thank you so much.
Thank you, sir. That was an awesome hearing from you all. Garima, wouldn't it be great to take a picture for such a sweet audience?
Surely, Keshav. We request and will be utterly grateful if everyone can momentarily turn on their cameras for the same. Okay, that's awesome. We'll take a screenshot right now.
Great.
Thank you so much, everyone, for turning on your cameras for the picture. It is finally time to end the excruciating pain we have all given you for the last 6 days. Vikram sir, do you have something to add?
Yeah, I'd like to
Yes.
say something.
Yes, sir. Please.
If it fits in the time, of course, I will not consume much more time.
Sure, sir. Do continue.
Very much thankful to the IEEE Bombay section, especially Kiran Talele. We are very old friends and meeting in IEEE activities regularly, though irrespective of my location. So this kind of a boot camp definitely will help to this institute in as it is located in rural area, where getting access to these kind of the knowledgeable resource persons is difficult. Even at institute level we are trying, but getting bunch of rather bouquet of resource persons and facilities is amazing. This definitely will help to our student. We have a small we can say incubation or pre-incubation center where currently 4 startups are working, but then they are into the preliminary stage working into it. As our strength is we have aeronautical branch. Out of these 4, 3 are working on the drone related application development and different inventions they are doing at drone level. Of course, I day to day interact with them, so I know what actually is happening. But definitely those people will get help and boost from this camp. As in the inaugural function, Professor Satyanarayan, chairman, said that there will be another boot camp. So what I expect is another, really should be another boot camp for startups, another boot camp for different activities related to startup. I am once again very much thankful to Professor Kiran Talale and all IEEE Bombay section office bearers and you two volunteers working amazingly. Thank you very much.
Thank you, sir. Thank you for your good word and inspiring word. We always love to work with you and take your advice and suggestions and new ideas. And we'll work in future and we'll continue our association.
Yeah, definitely. Thank you.
Thank you, sir, for sharing your thoughts. It is finally time to end the excruciating pain we have all given you for the last 6 days. Time to finally get some caffeine. But as they say, no gains without pains. I'm sure this pain will help you walk the path towards future unicorn.
Thank you, everyone. The certificates of the participation will be mailed to all the attendees shortly. We wish you best of luck for your entrepreneurship journey ahead and hope to see your participation in the future events of IEEE.
On behalf of the entire organizing team, these are your hosts, Garima Gupta and
Keshav Thosar.
signing off. Stay safe and have a great day ahead. Thank you, everyone.
The session is over.
Thank you.
Thank you, ma'am. Thank you, sir, for attending.
Recording stopped.